I see some results still pouring in. Give it a second. Okay, I think majority of folks have voted. We can share the results of the poll. Um, the majority of individuals are joining us from the eastern U.S., but we have a good number of friends who may not have been able to join us had we held the event in person. So it's nice to have new people joining us this year. Before I introduce our moderator for today's program, I want to take a minute to talk to you about Washington Council of Lawyers. We are a voluntary bar association in Washington, D.C., committed to ensuring that our legal system treats everyone fairly, regardless of money, position, or power. Our current strategic plan focuses on training, developing leaders, advocacy, and building community. Being a Washington Council of Lawyers member, sorry, loops you into great programs like the program today and also into events like our summer forum, which kicks off next week. You can learn more about our upcoming events on our website. Being a member also means that you're part of a community of lawyers from across sectors, gathered together with the common cause of ensuring access to justice. If that sounds like you and you're not already a member, I encourage you to join. You can sign up online at wclawyers.org. We also encourage you to follow us on social media. For today's event, you can follow us on Twitter with the handle @WashLawyers. We are using the hashtag SCOTUSPress. As we encourage membership in our bar association, I thought now might be a good time to see who all's in attendance with regard to different parts of the legal sector. So let's do another quick poll. What best describes your legal practice or legal experience? I see some folks are still answering. Give it a few more seconds. All right, I think the majority of individuals have responded. Fantastic. I see we have strong representation from law students, which is very good to see. And also some folks from outside the legal sector, which is also good to see. All right. So I'd like to now introduce our moderator for today's discussion, Arthur Spitzer, Senior Counsel for the ACLU of the District of Columbia. Before becoming Senior Counsel, Art was the legal director for the organization from April of 1980 to April of 2020. His work has spanned the range of ACLU issues, including many of the topics that will be discussed today, and many topics that have occupied the attention of our country over the last months. In Schroer versus Billington, Art represented a trans woman who was fired by the Library of Congress when she disclosed her status. In Abate versus Ramsey, Art represented some of the nearly 400 protesters arrested at an anti-World Bank demonstration in Pershing Park in 2002, challenging their illegal arrest and inhumane detention, and resulting in a settlement that included major changes in DC police practices in demonstration situations. He has also represented the White House Vigil for the Equal Rights Amendment, in a case which challenged restrictive regulations for demonstrating near the White House. Art had a major hand in crafting the legislation that created the DC Police Civilian Review Board, now known as the Office of Police Complaints, and the First Amendment Rights and Police Practices Act, a model statute governing DC police conduct during the peaceful exercise of free speech rights. In the Supreme Court, Art successfully argued Ake versus Oklahoma, which ruled that poor criminal defendants are entitled to free expert witnesses when needed for their defense, just as they're entitled to free lawyers. He has taught a course in demonstration law at the University of the District of Columbia School of Law. His dog is Taxi, His cats are Tigris and Euphrates. He is not and has never been related to former New York Governor Eliot Spitzer. And with that brief introduction of a very extensive and impactful career, I will turn the program over to Art.
Thank you, David, for that very generous introduction. Many of those cases were quite a few years ago, but a lot of it is coming around again. I now represent a group of plaintiffs in a lawsuit arising out of the Lafayette Park events a couple of weeks ago, where President Trump had the square cleared so he could walk to St. John's Church with his Bible. So we'll see what happens there. So welcome from the empty Supreme Court chamber behind me. Most of our panelists today, as David mentioned, are not the ones whose names were advertised because they're still busy working on their stories from today's opinions. But we've assembled a panel of equally interesting journalists, plus a couple of distinguished lawyers who practice at the court on a regular basis. And why don't my panelists all open up their video now so the audience can see you as I introduce you. There we go. Amy Howe, why don't you, yes, wave at us, who's with us from our original panel, is a reporter and an independent contractor for SCOTUS blog, and until a few years ago was also its editor. Before turning to full-time blogging, she served as counsel in over 24 merits cases at the court and argued 2 cases there. She has taught Supreme Court litigation at Stanford Law School and at Harvard Law School. She's a graduate of the University of North Carolina at Chapel Hill and holds a master's degree in Arab studies as well as a law degree from Georgetown University. When you go to SCOTUS blog for a concise and accurate summary of the decision that just came down, that's Amy's prose that you're reading. The next panelist is Linda Wheeler, smiling in the middle of my screen. She's a senior legal reporter at Bloomberg Law, covering litigation and legal issues involving healthcare and employee benefits. Previously, she covered the Supreme Court and federal court cases of interest, including Paul Manafort's fraud trial for 3 years. It's a beat that she created for the Hill newspaper here in DC after covering federal regulations for the Hill previously. Like all good reporters, she worked her way up, starting as a breaking news reporter and then covering county government at the Post-Star newspaper in Glens Falls, New York, a beautiful town just south of Lake George, where I've often enjoyed the summer weather. And before moving to Hampton Roads, Virginia, where she covered economic development at Inside Business, and then coming to DC to work on the Hill. Mark Walsh, hello Mark, is a reporter specializing in coverage of the Supreme Court. He writes the Supreme Court report column for the American Bar Association Journal, and also the regular View from the Courtroom feature for SCOTUS blog, of which I bet I'm not the only faithful reader. He's also a contributing writer for Education Week, where he's covered education issues in the Supreme Court and lower courts for more than 25 years, and he's the author of the School Law blog that they sponsor. Mark has a degree in journalism from Northwestern and has lectured about education law at Harvard. Kevin Daly, Kevin, is the Supreme Court reporter at the Washington Free Beacon. He's been covering the court for them and for a previous publication for the past 4 years, and graduated college only 5 years ago, so he has rapidly rocketed to a very prestigious beat. He went to college in Buffalo, basically across upper New York State from Glens Falls, so he and Lydia can compare notes about the Erie Canal. Andy Pincus graduated from Yale College and Columbia Law School, and after a clerkship and 4 years at the Solicitor General's office, he's been a partner at Mayer Brown for most of his career, with the break to be general counsel at the Department of Commerce from 1997 to 2000. Andy has argued 30 cases in the Supreme Court, including 2 cases during the same week in 2018, and that means Monday and Wednesday, not Monday and Friday. Maybe he'll tell us how he managed to pull that off. Andy co-founded and is the co-director of the Yale Law School Supreme Court Advocacy Clinic, which provides pro bono representation in 10 or 15 Supreme Court cases every term. We've been lucky enough at the ACLU that Andy has done some Supreme Court amicus briefs for us. Beth Brinkman is co-chair of the Appellate and Supreme Court Litigation Group at Covington and Burling, which she joined in early 2017 after serving as Deputy Assistant Attorney General for appellate litigation in the Civil Division at the Justice Department during pretty much the whole Obama administration. Beth graduated from Berkeley and Yale Law School, and after clerking for Justice Blackmun, took an unusual detour to be an assistant federal public defender here in Washington, where she handled about a dozen felony jury trials, which probably makes her unique among leading Supreme Court practitioners. She then worked at the Solicitor General's office from 1993 through 2001, when she argued her first 18 cases before the Supreme Court. She's had 7 more in private practice, arguing her 25th case last year. Members of the audience should feel free to post questions using the little Q&A feature that you'll find at the bottom of your screen as you go along. If there are questions that seem to be relevant to something we're discussing, I'll try to ask them as they come up, but we'll also save some time at the end for a Q&A session. Let's start with the breaking news. This morning, the court decided Patent and Trademark Office against Booking.com, holding that adding a .com to the end of a generic term can give you a trademark name. And also Espinoza against Montana Department of Revenue, a free exercise case. And Mark Walsh, you actually traveled out to Kalispell, Montana last September to file a background piece on this case in advance of the argument. Why don't you tell us about the trip? I hope it was fun, and about the case. Unmute yourself.
Can you hear me?
Now I got you.
Thanks, Art. I did get to go to Kalispell, Montana back in September for this case, which was looking like it was going to be argued in December or January, and it ended up being argued in January, and I would normally wait, but the location where these petitioners, the parents, were from is right near Glacier National Park. And so I kind of timed things and was told that, you know, the park starts to close by middle of September. And yet I had to wait for school to open, and that was right around the beginning of September. So right after Labor Day, I was there in Montana, visiting with these parents, visiting Stillwater Christian School, where they were using their scholarships from a private organization that are funded by a $150 state tax credit passed by the Montana legislature in 2015. It's a very modest program, very modest tax credit, but it does help some of these parents. And then ended up talking to the state side of things when I got back to Washington. So it was a great visit, and it's just great to get out for that kind of a site visit in a case. The decision today, obviously, was 5-4, striking down the Montana Supreme Court decision that had ruled that the state constitution's no aid provision meant that this program could not operate, and the state court had set aside the entire program. And today, Chief Justice Roberts wrote for the court upholding the free exercise challenge brought by these parents to that, actually, you know, the state agency, the Department of Revenue had created some rules that said that the scholarships could not be used at private religious schools, and the state Supreme Court had then struck down the whole program. But that program is presumably reinstated now.
So I noticed there was some language in the opinion that suggested there might be a distinction between discriminating against schools, against a school because of its religious status, its religious affiliation, and avoiding state money going to actual religious instruction. Do you think the decision left the door open to a state to say that a school that participates in this kind of program has to make sure that state aid goes only to gym or typing or something like that?
I'm not sure that this court would ever rule that way. That distinction was, pointed out in the Trinity Lutheran, a case from a few years ago, and so there are some questions like that that are open. We had 7 opinions today, I think. So even I was still going through the opinions as I'm writing my stories and breaking away to do this. But yeah, that's just one of the things we'll have to see.
Amy, usually the court's finished for its term before the end of June, but now we're heading into July with 6 important opinions left to go, including the Trump tax returns case and a case about whether members of the Electoral College are free to vote for a different candidate from the one they were pledged for, and a case that's been very difficult for the court. It's been re-argued early this term and still not decided about whether half of Oklahoma is still Indian country. Do you have any idea when they'll finish for this term? And do you have a guess why it's taking so long?
We don't have any sense of when they're going to finish. As you said, they usually are finished by now. And usually when we do this panel, and by the way, thanks for having me. This is a really fun event to be part of. I attended it for the first time as a summer associate back a while ago, I'll just say, at this point, when I was a summer associate at Steptoe and Johnson. And one of the young associates who was in charge of supervising the summer associates back then was Nancy Lopez, although that wasn't her name then. So that's for all of you who are planning to come back to Washington as lawyers. The Washington legal community is a very small one, which is a wonderful thing. But anyway, so yeah, so usually we're discussing the term because it has already ended at this point. Because of the pandemic, the justices had to postpone their argument session in March and in April, and they took 10 cases from those 2 sessions and combined them into one big argument session in May. So, to a certain point, we'll cut them a little bit of slack because they were working a couple of weeks later, hearing oral arguments a couple of weeks later into the term than they normally would be. So it's not that surprising that they're not finished on time. I mean, I think the counter argument to that is that for all of March and April, they weren't hearing oral arguments. And so theoretically, they could have been using that time to finish up some of their other opinions. They're only going to issue somewhere around 56 opinions this term, which is one of the lowest levels in recent times. But I think as lawyers and reporters, you can sort of work expands to fill the vacuum. And some of their very last arguments in the May session were some of the biggest, involving the president's tax returns, which they heard on the next to last day of the session, and then the faithless electors case, which was the last day in May. So it's really only been just about 6 weeks since they finished up arguments. So I'm not actually that surprised that they're not finished yet.
Let me throw out a question to anyone who'd like it. We've had a number of opinions yesterday and today. Any front page headlines about a couple of them. Was anyone surprised at the outcome? Does anyone want to talk about what happened and why? No takers on that. I'll ask a more specific question. In June Medical, the abortion case, all 6 male justices filed opinions and none of the 3 female justices filed opinions. That doesn't seem like just a coincidence, but Beth, did you read into that tea leaf? You got to unmute. I'm not hearing. Is anyone hearing? There you go.
No, but okay.
No,
Can
that
you
was
hear me
Amy.
now?
Yes.
Okay, great. I took it as perhaps the women just didn't feel a need to write anything. And I think perhaps some of the other justices really did feel a need to write. I thought it was a very interesting opinion. And I think it really showed the Chief Justice taking on the duties of a chief and stare decisis and being very explicit about that. And I think he had a lot to say about what he perceived as mischaracterizations of his opinion by other justices. So there was definitely a back and forth between those justices who did write on that.
So I'm especially grateful to the journalists who are with us today, since most of the journalists who were scared to be ran for the hills as soon as they was going to be a decision day. So thank you all for yeah. What's your day? What happens starting at 10 o'clock?
Thanks so much for having me, Art. You know, days like this are always busy. Can everyone hear me, by the way? Yeah. Oh, good. Okay. So yeah, days like this are always really busy. It starts kind of at 9:30, getting prepared, making sure that you're ready to go. And then for the next 2 hours or so, you're just kind of running on adrenaline and trying to get your story out as quickly as possible, get a tweet up. And that's why pre-writes come in really handy when it comes to Supreme Court decision days. Being really prepared helps alleviate that stress and makes your editor really happy when you can file quickly.
So tell me what a pre-write is.
So a pre-write is, you know, something that we do in preparation for a decision. We get all the background paragraphs written about the case. It's, you know, what the case was about. And then we write alternative leads for the top of the story, where we think that the court could potentially go with this. And so several times, you know, you have several options for leads. And so then once the decision comes down, you're able to kind of decide which one of the pre-write works and, you know, ship it off to the editor pretty quickly so it can post online. At Bloomberg Law, we like to have these breaking news decisions up as quickly as possible. So within 5 to 10 minutes, even 10 minutes is too long. So really quick. Some of them we have already ready to go in our system, and we're just ready to hit the publish button. That being said, sometimes you can never fully prepare for what the court is going to do. Some decisions all throw us a curveball. And I specifically remember when 2018, I think it was their first time ruling on partisan gerrymandering. I was not expecting them to kind of, you know, kick the cases back down on procedural grounds. I had like no pre-write lead ready for that one. But so it's just a part of the job. You just gotta roll with it.
You mentioned that you also tweet. So at the same time, you're trying to get a story up in less than 10 minutes. Are you tweeting?
Yeah, we're tweeting. We're trying to tweet as quickly as possible. You know, you want to get an initial tweet out that says what the court held. And also, oh, are you frozen? Oh, there you go. Okay, I thought you were frozen a little bit.
Yeah,
but
I was frozen. So
okay.
So at the same time, you're trying to get a story up in less than 10 minutes. Are you also tweeting? Does the tweet come first?
Yeah, I usually try to jump on Twitter first and put what the decision is and then immediately alert my editors, or sometimes it's vice versa. I can alert the editors which pre-write to use and then jump on Twitter and issue the decision, you know, write my tweet. And the best thing about Twitter is there's actually quite a bit you can do now with 280 characters. I can also go back after my initial story is up and add another tweet to my first tweet. You just reply to your own tweet and we create a Twitter thread about the court's decision. And so then you're kind of having a conversation. And all the while I'm watching, you know, the reaction on Twitter as well, because if I'm not the one who's writing, say, the breaking news about the decision itself, I'm still waiting for it to come down because we do second day stories, which is a look at the ramifications and implications of the ruling and what, you know, the broader impact. And so I'm looking kind of for that fresh angle. And so I'm watching what's being said on Twitter. I'm looking for reaction and trying to figure out what to do next. What's the next story about this case? And sometimes that's really easy. You know, you can, the second day angle presents itself quickly, and at other times it's a little bit more complicated and takes some time. But that day two story Still has to be filed by 3, 4 o'clock, sometimes 5 if my editors are being generous, but it's a quick turnaround.
Yeah. Have you had day 2 stories where you sort of said, well, maybe my day 1 story wasn't quite the right approach to this case? Maybe it really means something different?
I definitely have had day 2 stories that, take a deeper dive and things that maybe I didn't realize that the implications of the case were so big. Some of these sleepers, at Bloomberg Law, we like to get into what we call the weeds. We like to write about some of the decisions that don't get the national headlines from some of the mainstream publications. And so sometimes I'm like, oh, hey, you all missed this really important decision that they just, issued. And so those are really fun cases to write about because, they don't get a lot of attention.
Now, Beth and Andy, are you tweeters? Do you have instant commentary on stuff?
No, well, I'm not. I'm not sure I have that much interesting to say. But also, if you're in a law firm, there's sort of process that you have to go through. Often clients, if you're involved in a case, want to be the ones to speak about the case. They're not enthusiastic sometimes to have their lawyers sort of pop off with whatever is at the top of their mind. And even if you don't have a client in the case, not involved in the case, there may be firm clients that have an interest in the case, or one way or the other, or both ways. And so it often is a difficult process to get something cleared in, even to issue a statement if one of the reporters on this event or others call and say, what do you think of that decision? To get the ability to clear all those hurdles and get something out takes some time. So no, I haven't jumped into Twitter yet.
I have a very similar experience as Andy, and I think it's even more significant because often the cases you're most interested in you're following is because you do have a client who's interested in it, and you want to strategize with them and give them background advice about it. And it's very difficult to find a different voice as the journalists get to have your own discussion of that when really you're out there looking at the various interests of clients and how that affects them. So it's a different role.
And so, Amy, you host a live blog from the Supreme Court on decision days, but electronics of any kind, even smartwatches, are strictly prohibited from the courtroom. So in a normal year, how do you manage to do a live blog when you can't be in the room?
Sure. So in a normal year, I am nowhere near the courtroom on decision days. I have my laptop set up in the press room, which is next to the public information office, where they hand down the paper copies of the opinions simultaneously with the announcements in the courtroom. So shortly before 10 o'clock on decision days, all of the reporters who are downstairs go into the public information office, and we sort of gather around 2 desks where they have the opinions in boxes. And there's sort of a pecking order for who stands where, and the folks from the Associated Press and Reuters in particular stand closest to the desk because they're going to grab the opinions and run out. So you don't want to be anywhere near them because they are quick. And so there's a little audio from the courtroom. And so at 10 o'clock, the audio comes on and you hear the marshal, and then you hear the Chief Justice say, Justice Kennedy has the opinion, or now was it Justice Kavanaugh has the opinion in such and such a case. And at that moment, the staff in the public information office will open up the boxes and start handing out the opinions. And so you take a copy of the opinion, and then I run back to my desk, sort of trying to look at the opinion as I'm walking, and then start typing. And I'll try to say, okay, I have the opinion in such and such a case. It's from Justice Kavanaugh. The vote of the Second Circuit is affirmed, and here's the vote, and this is what the holding is. And meanwhile, as I'm typing that, I'm keeping an ear out because Justice Kavanaugh will be reading the summary of his opinion on the bench, so that when he finishes, I can go back into the public information office and get the next copy of the next opinion, if there is one. If it's Justice Alito who's reading an opinion announcement in particular, you have to be very careful because sometimes Justice Alito will only read a couple of sentences. He'll say, this case is about such and such, the opinion of the decision of the Fourth Circuit is reversed, and I'm out of here. And so then you have to run back pretty quickly and go get the next opinion. So meanwhile, Mark will be upstairs most days, or pretty much all opinion days, capturing sort of the drama of the courtroom for SCOTUS blog. But the drama downstairs is sort of the shuffle back and forth between the Public Information Office and the press room with the opinions.
And how has this year been different for that exercise?
This year is very different. You know, we're not in the Supreme Court building at all, obviously. So you know, it's really nice to see people like Mark and Kevin and Lydia. You know, we don't have paper copies, which is a really big difference. You know, and so on the day that the Supreme Court, I guess it was a little over a week and a half ago, it seems like a lifetime ago already, the Supreme Court issued the decision in the Title VII cases. The court puts them up on the website, and the website froze up. So, you know, the reporters, just like everybody else, were just hitting refresh, trying to get copies of the opinions and just waiting for them because we don't have paper copies. So it's fun to be on the live blog, sort of interacting with people, but it's not the same as, you know, and I'm still able to do that in the courtroom, but obviously we'd all rather be in the Supreme Court building for many reasons.
Kevin, I haven't given you a chance to really talk yet. How do you cover Supreme Court cases? Do you attend the arguments? Do you read the transcript of the argument if you can't be there? How much of all that preparation do you do?
Well, first of all, thanks very much for having me. It's a great pleasure to be here. I often, though not always, attend arguments. Going into arguments, I try not to go in cold. I think you really have to spend time with the briefs to write about the case with any degree of confidence. Reading the reply briefs at both stages is a good quick and dirty, I have found. But for the bigger cases, I think it's necessary to sit with the briefing in full and the decision below and amicus briefs that people are recommending. Very much like Lydia, I pre-write many of the court's decisions and share them with my editors in advance of opinion announcements. And those pieces are pretty formulaic. I'll leave the first few graphs empty with a couple of competing thesis paragraphs that try to place the court's decision in the wider sweep of things, and then maybe 500 words of exposition. I have to say that I'm loving the 2 minutes of uninterrupted speaking time that the advocates get these days, because most of them open with a simple and elegant frame that I can use for argument and decision pieces. And then when the opinion comes down, first I look at the lineup and then I read the syllabus, and that takes maybe 2 or 3 minutes. And at that point, I'm comfortable saying what the court has decided, at least at a general level. I try not to look at Twitter until my story is up. And then the rest of the day is reading opinions and updating my original story periodically until the mid-afternoon. One other thing I'd say I thought was really interesting, Linda Greenhouse did an interview for this great blog called High School SCOTUS some months ago, and she revealed that she often read the dissent first when opinions come down. And her thinking was that the dissent will always plot the path the majority took, the path it could have taken, and things like that. So it's a really excellent roadmap to the opinion, so it could be a good place to start.
Interesting. So that prompts me to ask Beth and Andy, have you had, I think you both have, some experience with the new uninterrupted 2 minutes. Are you in love with that also? Is that a great step forward for advocates?
I think it's a nice step forward. I think it gives a real value to the introductory experience. The Fifth Circuit had a practice like that for in-bank because their court had gotten so big, and I clerked on the 11th Circuit, which had adopted that for in-bank. So I was used to that kind of ability when you had a large bench to do it. So I think there's a plus to it. I don't think any of the justices are going to be stymied in their ability to question the advocate. They're quite good at that.
Yeah, I found it really useful that the argument that I had this term, we were bottom side where my client was the respondent, and to be able to sort of reset the argument after the other side had sort of taken its shots and heard the questions that the justices asked was really a very, very useful sort of moment to pick up on what was being focused on and sort of integrate it into our view of the case. So I thought really valuable, because in the old days, you would stand up as the respondent, and the justices were all warmed up, so they just start asking you questions right away, and you'd have no chance to sort of reset the view of the case. So a very valuable piece of real estate.
I would just emphasize that sometimes happened when you were still making your way to the lectern. They would ask you questions before you were at the microphone.
So as long as we're talking about argument, the telephonic arguments, the thing had, am I coming across?
Or you're freezing up a little bit on us.
Freezing up on
Yeah,
us.
sorry. So I was saying the telephonic arguments this spring were obviously very different. I don't think either of you had a telephone argument this spring, but did you listen to them? How did it strike you? Was that a would you wish that they took turns asking questions when they resume having real arguments, or was it much less fun?
I thought the ordered questions was much less fun. I think it loses some of the kind of organic development of the questions and the justices playing off of each other. I thought there were two great benefits from it, and there's been a lot of discussion of this, but I think it's worth repeating. I think hearing Justice Thomas's questions was terrific. Really being able as an advocate to have the opportunity to respond to questions from all the justices is powerful. And I thought that the whatever it was, the kind of the format encouraged that greater participation was terrific. The other thing I thought was good was a little less interruption. That was good. But what you do lose is kind of organic way the arguments develop, and perhaps that comes with interruption. Andy, what do you think?
No, I totally agree. I think it was good that everybody had a turn, but you sacrifice the sort of view of the case developing during the 60 minutes in a way that I think made the argument less fun if you were an advocate and maybe less useful if you were a justice. People got their individual questions answered, but a lot of what goes on in the oral argument, really is the justices using the advocate to communicate with each other and to respond to points that one justice has made through his or her questions. And because everybody had their turn, once that relatively short time was up, then it was on to something else, and maybe some justice who had a totally different take on what he or she wanted to talk about. So I thought at the end of the day, probably necessary for a phone, especially an audio only argument, but didn't seem nearly as fun. And I don't know if it was as useful for the justices at the end of the day.
It also did not allow one justice to follow up on a back and forth with another justice. And I think that was really unfortunate also.
I did I did a moot court, actually a couple of moot courts for people who argued during that time. And one thing, that you realize is how much as an advocate you use visual cues, when to stop because a justice is leaning forward or is about to ask a question, when you can see in someone's face that maybe you haven't really answered their question and you have to go back and do a little bit more, and you don't have any of that if it's just over the phone. And what happened, because most Supreme Court advocates, have a lot to say, is you really had the Chief Justice or the justices asking questions, cutting off the advocate even more than they did in the pre-pandemic days, because the justices wanted to get their second or third question in. And as an advocate, you wanted to fully answer the question that they asked. So it definitely loses something just being audio only.
We were talking a few minutes ago about how quickly the reporters have to get their stories up. Since I don't usually have lawyers on my panel, let me ask you a similar question. If you've got a case with a client who's involved, or maybe a client who's not a party but who cares a lot about the case, how quickly do you need to get in touch with them? Do you have time to pick up the phone line?
I usually try and give the client advance warning that the case is coming. You can get pretty good at predicting it. As everyone knows, there are only so many days on which opinions are announced. So giving that heads up so the client knows if they're going to be available is great. And then the most important thing for me is to get the opinion. I don't want to know the bottom line. I want to be able to see exactly what the opinion says. And I send that to my client right away so they can read it at the same time. And then we have a follow-up discussion after we've been able to go through it. I was in the courtroom the day the Affordable Care Act opinion came down. And if we sat through the first 5 or 10 minutes of that, you would have thought the case was going one way. You know, you have to analyze the entire opinion, and you really want that for your client, particularly procedural aspects that might not be key to the reasoning might be very important, whether there's a remand or a particular perspective that they take on an issue could be very important to your client's business and might not be what the headline is about.
But I agree with Beth. Your client wants to know the instant you know that their case has been decided and wants to get the opinion in their hands as soon as you can. You know, for a lot of companies, you know, there are significant communications aspects, brand aspects to how the decision comes down and what they want to say about it. And so they want to have the decision in their hands. They want to talk to you about what it means, but they want to know to sort of ring the bells in the rest of the company that this is decision day and everybody should get ready. Usually they have a plan about how they're going to react to the decision, and they sort of start putting that plan into operation.
Yeah, it's a really different world from when I was a young lawyer. I'll tell a little story of my own. I used to go to Supreme Court decision days in the 80s, pre-internet, and for that matter, before people had fax machines. And I would sit upstairs and hear the decisions come down. I'd go down to the public information office and get on the line for picking up paper copies. And actually the staff there was very friendly to me, and I could usually cut the line. And then I go to a telephone booth in the basement of the Supreme Court building. Of course, there are no telephone booths anymore. And I'd call the ACLU's National Legal Director in New York, and I'd read him the syllabus of the opinion so that he would know what had happened. So when the press started calling him, he would have some idea. And then I would walk to the nearest FedEx office on Pennsylvania Avenue, where for $1 a page, I could fax the decision to him. I could actually fax it to a FedEx office in Manhattan. And he could walk there and pick it up so that he could read it the same day. And everybody else was waiting till the US Law Week came in the mail 2 days later. So the ability to get the opinions in the hands of your clients instantly is either a wonderful thing or a terrible thing. Kevin, does your publication ask you to cover every Supreme Court decision? And if not, how do you pick which ones to focus on?
Some are obvious. Other times my editors will give me a little bit of deference as to what we're going to cover and what not. I would say on balance, we cover about 40% of the merits decisions, and then a lot of attention to things that are happening on the cert docket and things like that.
And what distinguishes the 40% that you cover from the 60% that you let go?
There are a variety of factors. Sometimes I want to call attention to something that the court has done that has been overlooked in the general media environment that deserves more attention. There are some priorities that our readership has that maybe is not shared by readerships of other publications. For example, our readership is a bit more right-leaning, and so I think it's more intensely interested in, say, a religious liberty case. So maybe a religious liberty petition, for example, that another outlet wouldn't give so much attention to, is something that we're going to cover. So a variety of factors.
Yeah, and Lydia, now you're covering healthcare related stuff, but when you were on the Hill, did you try to cover everything, or did you also pick and choose?
When I was at the Hill, we definitely, my job was to pick and choose what I thought, a general audience was most interested in, and chatting with my editors about what they thought too. They left a lot of the decision-making up to me. The Hill had never had a designated legal reporter prior to me. So that was, kind of I learned as I went kind of which cases to cover and which not. And there were some that I thought were very interesting that my editor would go, no, we're not going to spend time on that. And I go, oh, darn, because it's a good question. It's a good legal argument. But yeah, it takes some chatting about what we're going to cover and what we're not going to cover. But anything to deal with the Trump administration or the Obama administration, when they were in office. That was always, interesting to our readers. Anything that had a political angle, for sure.
Mark, I don't think you do a view from the courtroom piece about every argument day or every decision day. How do you choose which ones to cover that way?
Well, so I've not been doing them this spring because I've been helping Amy with the live blog, but in normal times, the view from the court actually started out, Beth mentioned the Affordable Care Act case. I was in the courtroom for that, and then actually wrote something for the ABA Journal about the drama of the Chief Justice's decision. I think everyone knows the backstory that down in the press room, some news organizations only looked so far into the syllabus and not far enough, and kind of got the initial call wrong. But it was very dramatic in the courtroom. And then next year, I started the view from the court for SCOTUS blog on the idea that there are no cameras there. There is quite a bit of drama. There are a number of reporters who like to go up to the courtroom for opinions because you just get that nuance from the majority opinion, and you will hear, the oral dissents. Some regulars who like to do that now are sort of under pressure to stay in the press room and get those web stories out, and they're from the bigger newspapers, and they have some other, people who can come to the court and go up there to catch some of that color and drama. So missing that, but obviously for good reasons, not getting to write those this spring.
So one piece that you did in the ABA Journal pointed out that this year is not actually the first time that the Supreme Court closed because of disease. And the audience might be interested to hear when that happened before.
Well, it was interesting to me that the court itself, when it announced the initial postponement of the March argument session, and then April got postponed, and then we came up with the May telephone arguments, the court itself relied on history and precedent just in making that announcement, and said that, in 1793 and 1798, the court had to postpone arguments because of yellow fever. And in 1918, the court had to postpone arguments because of the Spanish flu, the influenza epidemic. And I ended up finding, out where I think the court staff had sort of relied on. There's a documentary history of the early years of the court for the 1790s, and some interesting letters from the justices about Philadelphia being this infected place. That was where the court met then, and even a letter or a Boston newspaper piece about a Supreme Court justice who traveled up there but was stopped per public order to be checked for any evidence of the yellow fever. So, just the fact that the court would want to rely on that kind of precedent was interesting to me.
So Amy, I've seen some speculation, or maybe it's really wishful thinking by journalists, that now that the court has had live stream broadcasts of their arguments, there's no going back. Do you share either that wishful thinking, or do you think it's realistic, or do you think the court's going to just revert to normal?
I think there's definitely wishful thinking. I wouldn't say that there's no going back. The Supreme Court obviously can do whatever it wants. I think there will be a lot of public pressure to keep the live audio. There was a letter, I think, from Senator Grassley to the court asking them to keep live audio, or even better, to go to video. The Supreme Court will do what it wants. But I do think that probably one of the reasons that they went with live audio rather than live video when they decided to hold the telephone arguments, they realized that they were going to need to give the public access in one way or the other, was because it was probably the lesser of two evils for them. And so I certainly hope that they will continue with live audio. I think that live video would be even better. I'd also love it if they went with live audio of the opinion announcements, which we're not getting right now. But I don't know for sure when they're going to be back in the courtroom. I'm sorry?
So then you
We could
wouldn't have to live blog anymore.
It's a live blog them. I mean, we could comment on the opinion announcements. We could live blog on them while they're announcing them.
Right.
Remember,
It would be
Amy,
lots
we
of
were not
fun.
getting those before. We were not getting live opinion announcements before. In fact, we have to wait about 6 months before
6
they.
months, exactly, which has
Yeah,
always driven me kind of nuts. So we'll see. I mean, I'm not taking it for granted that the justices are necessarily going to be back in the courtroom hearing arguments in October. So they may not have to make this decision for a while.
If I may, I think that the May telephone argument has sort of cut against courtroom access advocates to the extent that I think the court has bought itself some time. I think that the justices can hold out the telephonic sitting as a noble experiment in broadcast that was interesting to try and that they might revisit at some point in the future. So I see it as a good way to kind of put the issue off for the foreseeable future.
Yeah, I think that if the court is going to do audio and continue with this live streaming or even advance to video, that we're going to have to see this broadly adopted in the lower courts first before the Supreme Court ever takes that step.
Someone in the
Pretty broad live audio in the lower courts. I mean, it's not like it's like it's hard to do. And we can have this debate another time.
Although surprisingly to me, a lot of lower court arguments are still audio only. There are some courts that use Zoom or use Zoom-like technology with rooms for the public and rooms for the advocates and the bench, but a lot of them are still audio only. So it's interesting. Baby steps, I guess.
I think they are baby steps, and to the extent there's at least audio, it seems no reason not to immediately release those tapes, those recordings, even if it's not live. Certainly just on a regular basis to be promptly released thereafter. That certainly seems a baby step that could be maintained, I would think, even when everything goes back to normal. I think video is a whole nother thing.
Do you think video would be good, Beth, as an advocate?
Yes, I do, but I don't think it's going to happen.
Andy, would you also like to see it for your arguments?
No, I'm really of two minds about it. I think it will change the dynamic, especially in highly sort of politically salient cases. And I think that's what the justices are concerned about. I argued a case against Paul Clement when he was in the SG's office that was a religion clause case. And, the government's position required him to say that, it would be okay for the president to use his discretionary funds to build a church on the grounds of the White House, which he said, and that was the right answer in terms of the justices understanding his position. He ended up winning the case anyway. But you could see in cases like that, things being clipped out of video especially and being used in ways that, might lead people to sort of pull their punches in how they answer questions and how candid they would be in argument. So I think that's the countervailing consideration.
So we could talk about this for an hour. I'll just make one other comment because I agree with that taking out of context. The example that just always gives me such pause is, if we could only see Brown v. Board of Education argued on a video. I mean, it's the historic just wealth of experience that we're losing. I mean, I would be happy if they videotaped them and then didn't release them for you. I would love to go back and see videos of some of those historical arguments and not have them taken out of context. I think that's a very good point of Andy's.
Yeah, I've wondered whether Andy's concern has been the court's concern, that not so much a statement by an advocate, but a question by a justice, which maybe is a devil's advocate question, would be on the evening news and make them look weird or extreme. I'm not much of a news watcher. From the telephone arguments this spring, did audio clips get on to the news shows at all? I don't remember hearing one.
Not much, really.
No, I mean, I will say, and I'm a huge advocate for the live audio, that the live audio really just kind of showed that the Supreme Court is the most functional or the least dysfunctional branch of government. They really came across well, the lawyers and the justices.
Yeah. So our host reminds me that it's time for another poll, just so that everyone at home is alert and awake and participating. So we're going to have a poll, and we're going to take a break for a second while Nancy does that. All right, thank you all very much. So one of my favorite questions to the journalists every year, and I didn't want to skip it this year, is a long question. Sometimes decisions are simple and easy to understand and report, but every term we get at least a couple where the lineup is much more complicated. And as most people who are listening know, the Supreme Court publishes a syllabus at the beginning of its opinion, a summary of the decision, and at the end they list who's written what opinions and who's joined what opinions. And so sometimes you get one that reads like this. One of this year's cases, Ramos against Louisiana, which had to do with the right to a unanimous jury verdict in state courts. Justice Gorsuch announced the judgment of the court and delivered the opinion of the court with respect to parts 1, 2A, 3, and 4B1, in which Justices Ginsburg, Breyer, Sotomayor, and Kavanaugh joined, an opinion with respect to parts 2B, 4B2, and 5, in which Justices Ginsburg, Breyer, and Sotomayor joined, an opinion with respect to part 4A, in which Justices Ginsburg and Breyer joined. Justice Sotomayor filed an opinion concurring as to all but part 4A. Justice Kavanaugh filed an opinion concurring in part. Justice Thomas filed an opinion concurring in the judgment. Justice Alito filed a dissenting opinion in which Chief Justice Roberts joined and which Justice Kagan joined as to all but part 3D. So that's a mouthful. And a question to the journalist, whoever wants to grab it first, what do you do when you see something like that at the bottom of the syllabus and you still have to get a report out as quickly as your editors, want something on the line?
I'll say quickly, that's maybe one where you do go to the dissent, because the dissent might be summarizing the holding as well as the majority or the syllabus. And, this was one from this term, and the DACA case was similar because there were some procedural issues. And then when you have justices concurring in part and dissenting in part, it's hard to figure out. But then, you get cut through it and you realize it's a 5-4 decision and the key issue in the case.
Yeah, that's exactly right. I think building on what Mark said and what Kevin had said earlier, last year with the census case was the same thing. We were in the court for the issuance of the opinion, got the opinion, took it back to my desk in the press room, and I'm sitting there. And usually, people start getting on the phone with their editors, telling them what's going on, and it's kind of busy. And there was just dead silence as people were trying to figure out what was going on in the decision. And I'm scanning through it, and the only thing that gave me a little bit of comfort was that nobody else clearly could figure it out either. And later on, after a couple of minutes, I figured out that if I had just gone and read the dissents and the concurring opinions first, it would have been crystal clear in about 30 seconds what was going on.
Yeah, I would just add on to that. Justice Kavanaugh has this very helpful tendency to summarize what the court has done when those fractured lineups appear, or at least he's done that a couple of times, and I certainly hope that trend will continue. So for example, in Ramos, there's a footnote at page 12 of his opinion that breaks down the different lineups, explains how the different justices are approaching Apodaca, how they understand how it interacts with this case, and whether or not it was actually overturned and things like that. And likewise in June Medical, he opened his dissent saying that 5 justices over several opinions had rejected the cost-benefit approach that the court took in Whole Women's Health. So sometimes when the court is deeply fractured, looking at Justice Kavanaugh's concurrence or dissent is a place to start. Could be a clue there.
Lydia,
I think
Justices
please.
just have, oh, go ahead, Lydia.
Oh, no, that's okay.
The justices have very different styles. So like in the Espinoza decision today, the Chief Justice sort of lays out the question before the court in the first paragraph, but he doesn't answer it. You have to go through. Whereas Justice Kagan, there was an opinion a couple of weeks ago. It was a lower profile opinion, but it's all in the first paragraph, which if you're live blogging or trying to get something out quickly is terrific. It's like, this is the statute. This is the question before the court. And here is the answer. And you're just like, hallelujah, thank you.
Justice Kennedy was like that in his opinions and in the courtroom. He would just keep people hanging.
I think that the general public doesn't realize that we don't get a vote count. Like the court press office doesn't give us that. We have to figure that out ourselves. And sometimes it's not immediately clear what the vote count is. And, we're trying to get the story up and, tweet out. And sometimes if you'll see, you can watch it on Twitter, like sometimes the vote count doesn't come out immediately because we're all still trying to tally it ourselves. And if you ask the court press office, that's not their job to tell you that. So they're like, nope, it's on you.
I'll flag one thing for the law students who are watching. And when you get the slip opinion for the when it first comes out from the court, at the top of the page, it identifies which opinion it is. So sometimes it says, opinion of the court. Then it'll say concurring opinion, but sometimes it'll say opinion of so-and-so or plurality opinion. There is the reporter, I believe, puts those labels on there. So when it's published, there is some help, but I think as Lydia was saying, you have to patch that together with the vote count they put out there also.
Could I tell a quick story? We mentioned Linda Greenhouse, who was a stickler for accurate reporting about those fractured decisions. And one time under Chief Justice Rehnquist, I arrived at the press room area, and in the hallway, we don't often see the justices, but I saw Linda speaking to Chief Justice Rehnquist just in a casual conversation, and she was pressing him. She felt the court had not precisely accounted for the vote of a justice in a particular issue in a complicated case. And Chief Justice Rehnquist was really none too troubled by this and just said, well, Linda, you're just going to have to do the best job that you can.
Right. So switching topics a bit, we've only had COVID amongst us for 4 months or so. But by my count, the court has already dealt with 6 COVID-related cases, all of them emergency applications of one sort or another. One had to do with voting by mail. 2 of them actually had. One had to do with voting by mail. One had to do with extending the time to get absentee ballots in before the primary in Wisconsin. 2 of them had to do with closing, governor's orders closing church services where churches were claiming that they had a right to go ahead and have their services. One had to do with closing businesses in Pennsylvania, that the line between essential and unessential was being drawn in the wrong place. And one involved the federal government, which was an effort to block the administration from enforcing its new public charge rule, that is not giving green cards to immigrants who are getting some kind of welfare, trying to block that on the ground that people are going to need government assistance now during COVID, even when they might not normally. That seemed to me like a lot. That got as far as some actual decision from the court. Did anyone else have a reaction to that? Do you think we're going to be seeing a lot more of that in the coming months and even over the summer? Or is this probably a passing germ, and pretty soon we'll be back to it takes 3 years to get a case up to the Supreme Court?
Well, even before COVID, people were writing about the so-called shadow docket, which is sort of what all of those kinds of applications are part of, and how it was taking an increasing amount of the court's time because the Trump administration was seeking Supreme Court intervention when there had been a lower court stay or injunction ordered in some case challenging something that the government had done. So I think this is just another example of that phenomenon where in the polarized world, country at least in which we live, nothing is ever really settled in the political process. And so whoever the loser is tries to press all the way through in the court system to get whatever relief they can get. So I don't think that's going to slow down anytime soon, COVID or non-COVID.
So Lydia, this COVID is sort of in your wheelhouse now as an expert on healthcare. One case that's been affected by COVID, although it doesn't arise from it, was postponed from this year till next year, Rutledge against Pharmaceutical Care Management, which is an important case and maybe even more important in light of the pandemic. Why don't you take a minute to tell us about the case and its significance?
Sure, I'd be happy to. So this case is a battle over an Arkansas law that actually prevents pharmacy benefit managers, those companies like Express Scripts and Optum RX, from underpaying pharmacies for generic drugs. There are trade groups that are challenging this law. They say that the Employee Retirement Income Security Act, which is ERISA, is a federal law that preempts the state law because it governs employee benefit plans. The attorneys and other journalists on this call will know that ERISA is not a topic that the justices love. Justice Ginsburg has actually said previously that she groaned about having to, that was her first decision she ever had to write on the court, was an ERISA decision. It's a very complicated statute. But so what's interesting about this case is that supporters of the law say that states need the freedom to come up with their own sort of solutions to combat what's alleged abusive practices by these companies. And there are more than 40 states that have laws like this. And so it'll be interesting to see how the court rules. The supporters of the law say that without it, that pharmacies could close. And, as we've seen during the coronavirus pandemic, is that this is a way that some people are getting, certain types of treatment that they need. They go in, and some of those CVSs and Walgreens are actually doing COVID testing right now. So it's not just, pharmacies are no longer a place where you just pick up your drugs. You get a flu shot, you check your blood pressure. So they're very worried about these laws being struck down and pharmacies having to close.
Let me ask you a follow-up question. You've had a variety of quite different beats: local government, business development, federal agencies, healthcare. How is covering the court different from all these other beats in your experience? What's the best thing about the Supreme Court beat? What's the worst thing about it?
Well, there are, not a lot of journalists that get to cover the court, and certainly much less people who actually get to go and sit and watch these arguments. And so it's really exciting to kind of be writing the first draft of history and what the court does. That being said, I feel like my experience leading up to this kind of prepared me for some of the complicated issues that the court addresses here. A lot of the legal issues in the lawsuits are over government actions, federal regulations. So understanding how the government just works, and also how their actions, impact, citizens and the public, is really important and gives me a different perspective. Something I love about journalism is that we all take a different route to get to where we are. And so, I miss a little bit covering, local government from my cub reporter days right out of college. That's why, it's sad to see local, publications closing, because journalists really are the eyes and ears for the public. We're going to those town hall meetings and sitting in and watching what your elected leaders are doing while you're, just worked a long shift and have to take care of your kids at home. So, I miss those days. And support your local newspaper if you don't. Subscribe. They need our money. So sometimes it can feel a little bit in Washington like we're in a bubble, but it's really exciting to be covering the court and to covering these issues. And, I'm just constantly learning every day. And that's what I love most about this job.
So that's probably a good segue to talk a little bit about next term. Two of next term's biggest cases, I guess they're consolidated, California against Texas and Texas against California, are the challenges to Obamacare. Late Thursday night last week, the Solicitor General filed the government's brief on the merits. I gather just from the news reports, asked the court to ditch the whole thing.
Yeah.
Lydia, can you update us on the state of play there?
Sure. As you mentioned, that brief came in on Thursday around 11 o'clock or a little after, much to the dismay of several reporters and court watchers who were sitting waiting for it. It wasn't really a surprise that the Department of Justice has decided to maintain its position that the entire law here should be invalidated. What's really interesting is the relief that they're asking for. They're asking the court to only issue relief limited to the provisions that impact the individual plaintiffs in the case that are challenging the law alongside with the state coalition of that brought the initial challenge. And so, the law scholars that I talk to say that, this is kind of like the Department of Justice is, trying to have its cake and eat it too here. They don't want the law, but they also didn't ask the court to issue an injunction to, against its enforceability, because maybe there are provisions later that they want to keep. So we're still making our way through the briefing in this case. The Supreme Court, to the best of my knowledge, unless it came out while we were on this call, they haven't released like a calendar yet. So we don't know when this case will be argued, but there is a good chance that we could see this come before the court, before the November election.
Yeah, and Art, if I've been involved in that case, I think what's scary about the Justice Department's position is it might be that only an injunction, that these plaintiffs might only be able to get an injunction limited to some parts of the law. But there's a pretty strong argument that if the court says the whole law is unconstitutional, the government's ability, for example, to keep paying for the expanded Medicaid that provides health care for tens of millions of people, and to keep paying the premium tax credits that pay for about 10 million or 11 million people to get insurance on the exchanges, that they'd have to stop because of some laws that say the government can't spend money that hasn't been appropriated. And if the law has been invalidated, there's a pretty strong argument that they can't do that. So I think in the real world, it might be these plaintiffs would only get limited relief, but the effect of the court's decision the day after it's rendered on the healthcare system would be cataclysmic.
There's an interesting little nugget in a case, I think, decided this week for this case to the Consumer Financial Protection Bureau case, Celia. One of the issues was there was the remedy and severability and whether to take parts of a statute or not. And I think that is something that perhaps some of the justices had in mind. It's difficult to know, but there's more and more of this. There's been a series of cases under whether various officials in the federal government were properly appointed, whether recess appointments or inferior, officers under the appointments clause. And there's always a question of remedy. What do you do if there is a violation? Does everything get invalidated, just particular things? So there was that debate between some of the justices and their opinions in Celia this week. So I think that'll be interesting to keep an eye on with this Affordable Care Act next term.
Yeah, a lot of people were, zeroing in on the Chief Justice, opinion in the Celia law case, because he specifically noted the disruptions that would be caused if they completely wipe out, the Consumer Financial Protection Bureau. And, a lot of people are saying, well, the same sort of disruption could happen, with Obamacare, because it's such a, essential, part of our healthcare system now. And, the Chief Justice said that we should be, Congress wants us to use a scalpel instead of a bulldozer when, trying to remedy these issues.
Mark, you're following another interesting case scheduled for next year, Fulton against City of Philadelphia. Why is that a case we should care about?
Well, I was thinking of maybe deferring to my panelists, because I was really going to read up on the latest briefs and that. I have been following it, but I was going to do that if I didn't have a busy decision day today, but I did. And I just don't want to misstate anything in that important case.
Fair enough. Fair enough. It's 4:18, so it's time to open up the Q&A part of our panel. And we've got one question that was posted a little bit ago, summarizing it very well. To what extent is Chief Justice Roberts voting what he believes in these cases where his vote is sort of an unexpected swing? And to what extent is he sending a message that he's not going to be President Trump's lackey? Does anybody think, well, who wants to speculate on what's going on with Chief Justice Roberts?
No, I think if you look at the Chief Justice's jurisprudence, if you think about the DACA decision and June Medical, the DACA decision is very consistent with what he did in the census case. He's a believer that government can do a lot of things, but that the procedural and substantive rules that apply to agency action and to government action serve important purposes and that they have to be complied with. And in both of those cases, he talked about the importance of the government being clear about the reasons that it takes certain actions and considering all of the possible ramifications before it takes those actions. And I think that's something that he believes seriously and that I think increasingly on the court. If you go back to sort of the olden days when I was in the SG's office in the 1980s, the government rarely lost administrative procedure or regulatory cases. It was a court that was pretty friendly to the exercise of federal power, both in the criminal sphere and in the regulatory sphere. And I think if you look at the court today, there's lots of concern about the federal government's exercise of power and the fact that it's important that it be subject to judicial review and that the procedural rules be complied with. So I think that is really of a piece with the Chief Justice's jurisprudence. And I think in terms of this week's decision, I think he's very concerned about respect for the Supreme Court and respect for the judiciary. And I think in June Medical, people will recall that the first question that came to the court was whether the Fifth Circuit's decision, which was to uphold the validity of the state law, should be stayed or not. And the Chief Justice voted for a stay. And part of the argument there was that the Fifth Circuit had essentially taken a case that was very, very similar to Whole Women's Health and reached the opposite conclusion. And if that was something that should be done, that was certainly something that the Supreme Court should do and not that a lower court should do. And you wonder whether that feeling may have influenced how the Chief Justice also voted on the merits.
I'd also say we hear John Roberts talked about a lot in connection with this concept of legitimacy, which I think is sort of a tricky concept to approach in any event. But I think maybe to put a finer point on it, it's a question of what's the blowback he's willing to live with. The Chief's alignments with the left of the court deeply inflame conservatives and commit them to the generational FedSoc bench stacking project and disruptive political alternatives like Donald Trump. That anger lingers for a long time and it's channeled into things that become permanent features of the political system. I do think that there's a plausible through line from the Chief's vote in NFIB to President Trump. But on the other hand, we also have liberals are living with this perpetual anxiety and knowing that their priorities and past victories turn on the whims of five people who have a different view on things. So if you're thinking about legitimacy in terms of popular assent to the court's decisions, I think it's a shell game you can't win. So I think the better way to think about it is what's the blowback that John Roberts is willing to live with?
Well, I don't know. I mean, you look at a decision like his decision on the Voting Rights Act, and I think that probably has had more of an impact on the political system in the country than almost anything you can think about. And that was certainly something conservatives wanted for a very long time. So I don't know that it's possible to say. I think legitimacy to me is not legitimacy about the court. It's the feeling that the government should own up to the reasons for its decisions. He was willing in that case, he certainly owned up to his view that the Voting Rights Act was unconstitutional and, got some praise from some people and some anger from other people. And I think, in the census case, for example, all he was saying was, you know, the reason that's being given is clearly not the reason that this decision is being made, and you should have to give the right reason. And, you know, you're the politically elected branches. And for politically elected branches, less for the judicial branch, which is elected, the people need to know the real reason why you're deciding. And then the people, if the people like it, you'll get reelected and you'll get credit for it. And the people don't like it, you won't. But that's part of what the APA and the system is designed to do, is to require those actual decisions to be put out there so that people know why their government is doing things.
So I have an interesting question from Jacob, who says, any advice for somebody hoping to cover the court as a journalist someday? Should I aim to acquire more journalistic experience or more legal experience while I'm still in my 20s? And for the non-lawyers on the panel, do you feel you've lost anything in your position as a reporter by not going to law school? So which of our journalists would like to take a swing at that?
Yeah, I'm happy to answer that. You know, I think that any legal experience that you can gain now early on is always beneficial. If there's any legal disputes that you're interested in, any legal issues that touch on the beat that you're covering to start with, that's kind of that's how I broke into this anyway. You know, I was covering for the Hill federal regulations, and then a lot of the regulations that President Obama were issuing when I first started were being challenged and then making their way to the Supreme Court. And since they didn't have a court reporter, you know, that was me. I was there. And then I just started kind of saying, well, there's also this other case that we should pay attention to. And I think it would be interesting to our readers for this reason. And then my editor said, okay, I'm listening. All right, go ahead, you know, do. And then it just evolved from there. You know, I do think that there are a lot of reporters that cover the court, especially, you know, in this town, that are attorneys and have law degrees. I work at a publication that's a nice mix of people who have law degrees and people like myself who are journalists. You know, we went to J school. And so I would say that there's still the opportunities there for both. If, you know, I wouldn't deter anybody from going to law school that wants to also be a journalist. I think there's jobs out there. They're difficult to get. At the same time, if you're a reporter like me who hasn't been to law school, those jobs are sometimes harder to get because you don't have that experience level, but they exist. And, you know, it's all about, at the end of the day, the stories that you produce and, you know, what's on the page.
Did the Hill find someone else to cover the court when you left, or have they dropped that beat?
No, they kept it, and they actually have 2 reporters now covering it. They needed a couple of reporters. They realized it was a really big beat because it's not just the Supreme Court at the Hill, it's all the lower federal courts as well. So any case of interest, and this administration has faced a lot of litigation. So it's been very busy. They're still holding strong with the court beat, and I wish them the best of luck.
So Lauren asks whether there are any predictions about how the court will decide the Trump tax return cases coming up in the next few days. Does anyone want to go out on a limb? Not so much. Here's an easier question. We talked about Ramos against Louisiana. Justice Kavanaugh had a concurring opinion in that case where he outlined his theory of stare decisis. Given that he's likely to be on the court for a long time, what, if anything, do you think that concurrence can tell us about what he's likely to do in future cases where stare decisis is an issue? Any predictions there? My screen is pretty much frozen. I hope others are not.
I'll go back to the Trump tax returns.
Okay.
I think the conventional wisdom, and, you know, obviously take this with a grain of salt because you never know exactly what's going to happen coming out of the oral arguments, is that the Supreme Court is likely to, it's going to be a mixed result for the president, that the Supreme Court could very well send the case back, the congressional subpoenas back, and say that the subpoenas were too broad, that the lower courts need to review them under a tougher standard, but then uphold the subpoenas from the New York District Attorney and say that the president does not have absolute immunity from subpoenas while he is in office. And so the upshot of that, by the way, would be that the congressional subpoenas go back, there's more litigation, the New York subpoenas are enforced, but because of grand jury secrecy laws, nobody sees the president's tax returns anytime soon anyway.
Good. Well, this webinar is being recorded, so your words are preserved, and we'll see.
Excellent, love it.
We'll see what happens. I don't see. I'm not seeing any new questions in the Q&A box, and we've only got a couple of minutes left. Some terms, there are real sleepers. There are opinions that are not obviously important that later on turn out to have been quite important. Did anyone spot a sleeper this term that they'd like to share with us? I don't have one this year myself, but maybe someone else does.
Trend that I think is maybe important.
I missed the first half of what you said, Kevin.
Could I highlight a trend that I think is maybe significant?
Sure.
So when we were doing these kinds of panels a couple of years ago and talking about the future of the court, I think a lot of us were expecting major changes in the area of administrative law. And I think that there's some reason to think that those predictions have not panned out. Over the last two orders lists, we have seen 2 denials in cases raising non-delegation issues. Both were pretty well briefed and looked like reasonably good candidates. This, of course, follows last year's case Gundy, which was the first non-delegation case the court had heard in decades, which led some people to think that there was about to be a springtime of the non-delegation doctrine. But now it seems that there are not 4 votes to even try for a revival of the non-delegation doctrine. Consider that in connection with the Kisor decision from last year, turning back a direct attack on our deference. If there are not 5 votes to overturn our, it is hard to see how there are 5 votes to overturn Chevron. So if the deference doctrines aren't in any danger and the much heralded springtime of the non-delegation doctrine got rained out, it looks like the campaign against the administrative state some of us were expecting is kind of a dud.
And one footnote I would say to that, I agree with Kevin. I think non-delegation and our and Chevron deference were on everybody's radar screen. The one thing that remains, though, I think on the radar screen is a lot of these administrative law cases that are involving the PTAB, the agency and the Patent and Trademark Office. And they've already had a couple cases about that. They upheld in oil states the constitutionality of it against several challenges. But there are a lot of issues that are coming out of that, including appointments issues, as I mentioned earlier. So those are of constitutional magnitude, and they do go to kind of that idea of limiting the authority or how someone who exercises a certain type of authority has to come into their office. So I think that is still on the radar screen. And there are a couple of cert petitions for next term.
I'd also caution against reading too much out of the cert decisions.
Right.
Between March and now, the court has really ratcheted down the number of grants. They're about half or less of what they've been in prior years. And who knows, but I think there may be a view that they don't know how they'll be functioning in the fall and loading up their docket with either lots of cases or cases that, require a lot of significant consideration, but that, are going to arise again if they want to decide them. It's just not something that they're interested in doing right now, given that they just don't know how they'll be able to function and how many cases they'll be able to decide.
Interesting. Well, my computer says it's 4:31. So it's time to wrap up. My thanks to everyone on the panel, and thanks to the audience for tuning in. And I'm going to pass it back to Nancy Lopez to say goodbye. Nancy?
Hello, everybody. My name is Nancy Lopez. I'm the Executive Director of the Washington Council of Lawyers, and I'm here just to say thank you. Thank you to the audience for being here. Thank you to the panelists for a fantastic discussion, and an extra thank you to Art, who had to try and cultivate this discussion in the middle of the Supreme Court term instead of shortly after the conclusion of the Supreme Court term. It was a serious challenge, and you very much rose to meet it. As Art said, this program was recorded, and we will send it out to everyone who's registered by email, so look for that in the next week or so. And I also want to invite people to our summer forum. It starts next Tuesday, a week from today. It is 6 panels, a keynote, and then 5 panels on different kinds of pro bono and public interest practice. And so you can find out information about that event on our website at www.wclawyers.org. And then I encourage you to get involved. Becoming a public interest or a pro bono lawyer is a really important thing to do. more so today than ever before. And so you can join Washington Council of Lawyers, you can attend programs, and you can just find out what's going on in the world of public interest on our social media. And so I hope to see you all again soon. And thanks again to everyone for being here today.
Thank you.